Good afternoon, everyone. Thank you for joining us for Legal Aid's Medicaid Home Health Services training. My name is Sylvia Soltis, and I manage Legal Aid's pro bono program. I'm joined today by my colleague, Andrew Patterson, a senior staff attorney from our Public Benefits Law Unit, and two sick kids at home with me, so I apologize in advance for any interruptions. We're grateful to have you with us. I'd like to flag a few items before we begin. First, we are recording this training, and after the training, we will share the link and additional training materials, including a manual to go along with this. Second, if you have any questions throughout the presentation, please feel free to type them in the Q&A box at any time. We'll be monitoring that throughout the training, but because we have a lot of material to get through, I want to at least flag for you right now that we're going to hold off on answering those questions until the very end. But I assure you, we have reserved enough time to go over those questions at the end. With those pointers out of the way, I want to share just a little bit about Legal Aid, especially for those of you who are new to our organization. Legal Aid is DC's oldest and largest civil legal services organization. And for over 90 years, we have been making justice real in individual and systemic ways for persons living in poverty in DC. We provide a continuum of legal services to clients in a variety of areas, including housing law, domestic violence, family law, public benefits law, consumer law, criminal record sealing, and some other areas. Legal aid, we receive thousands of requests each year for help, and yet there is always a gap between those that come to us and those who we can take on as clients. So our pro bono program allows us to expand our impact in DC and chip away at that gap by providing legal assistance to hundreds of additional individuals and families each year. The last time we held this training was in 2019, when we observed Medicaid beneficiaries were being negatively impacted by changes made by DC's Department of Healthcare Finance. Many of you were able to help us back then to ensure folks were able to retain critical home health services and make sure they were not lost. Then, of course, COVID happened, and we haven't seen these cases in about 3 years. So today, I'm so grateful to have you here with us, because as the public health emergency protections expire, we know that Medicaid beneficiaries could lose their current Medicaid coverage through a process called unwinding. Andrew is going to walk us through all of that, the restart of renewals. Andrew is a senior staff attorney in the Public Benefits Law Unit. He represents clients in a variety of legal matters, including Medicaid and Medicare, food stamps, TANF, unemployment insurance, and several other DC health programs. He also is a significant contributor to our public policy and advocacy efforts here at Legal Aid, with a particular focus on district healthcare programs. So, Andrew, if you wouldn't mind, you can unmute and take us away.
Sorry that I start with a cough. And thank you, Sylvia, for that introduction. And I just want to say thank you to everyone for being here and for participating in this training, and for hopefully taking some cases in the future. As Sylvia said, a lot of, all DC Medicaid enrollees have not had to renew their coverage, and most of them who receive home health services have not lost their coverage for the better part of the last 3 years due to the public health emergency. That is unwinding. Notices are going to start going out at the end of this month or the beginning of April for either reductions in care or possible terminations of Medicaid coverage for certain populations. Now, people should not have their coverages reduced or terminated immediately. Most people will be given either a 60 or 90-day notice, and that notice will have appeal rights. So we're going to talk a lot today about the appeal process and how to represent clients in those appeals. And hopefully we will be able to help a lot of clients before their terminations or reductions actually go into effect. Excuse me, I'm still getting over a lingering cough from a cold I had like weeks ago. And so I want to go ahead and get started on the training. Just a couple of quick points that I want to make. Number one is I'm going to move there. We do kind of an overview of Medicaid and an overview of the application process for these programs. I'm going to move through that part a little bit more quickly because most of what we're going to focus on and most of what the cases that we will be referring out are going to be are cases involving appeals, cases involving people who are already enrolled in some type of Medicaid home health service and are having that coverage threatened with reduction of hours or termination. So that is what I want to spend most of my time on today. But I think the overview information is helpful from a background perspective, and to the extent that it is ever relevant in any of your cases, you can always talk to your legal aid mentor, which will be assigned to every pro bono case that goes to a pro bono attorney. One other thing I want to mention is that you'll hear me refer to both personal care aid or PCA services or hours as well as home health services. I'm basically using those interchangeably. I've tried to sort of pick one or the other and it doesn't really stick. So essentially what we're talking about, the main Medicaid benefit that we are talking about in these cases are home health services where people have a home health aide who comes to their home and helps them for some amount of time during the day with their activities of daily living. So if you hear me refer to PCA in one part of the training and home health in another part of the training, I'm talking about the same thing. And then finally, and I think this is especially relevant for people who took some of these cases a few years ago, but there have been a handful of changes in some of these programs and some of the appeal procedures that have taken place since then. So for a little bit of this, I think we at Legal Aid will be learning along with you about the best way to handle some of those. But I'm going to identify those in the training. And of course, anytime you have a question, if you've taken one of these cases, you can reach out to your legal aid mentor and they will be able to give you some thoughts and some guidance on how to proceed. So just a quick overview of the presentation. We're going to do an overview of Medicaid and home health services in the District of Columbia. We're going to talk about medical necessity, which is the standard that DC Medicaid uses, that any Medicaid program uses to determine how much care someone is entitled to under the program. We're going to talk about termination and or reductions of home health services. That's going to be the main adverse action that we and pro bono attorneys will be appealing in these cases. We're going to talk about the appeal process and the fair hearing process. There will be an overview of that. And then we're going to talk a little bit at the end about some pointers on client representation in these types of cases, like initial steps after the client meeting, after you get a case, and just some sensitivities for this client population. So speaking of Medicaid in DC, there are two main government agencies that oversee the Medicaid program. The primary agency is the DC Department of Health Care Finance. They are what is referred to in federal Medicaid law as the single state agency that oversees the Medicaid program. DHCF is how it's normally referred to, and DHCF sets policy. They make coverage determinations. They or their contractors, which are called managed care organizations, which we'll talk a little bit about, but managed care organizations are essentially contractors that provide Medicaid coverage to certain Medicaid populations. They're the ones who make coverage determinations. And they contract with third-party vendors to do certain types of assessments, one of which will be key to what we talk about today. There is another DC government agency that is relevant to Medicaid, which is the DC Department of Human Services. The DC Department of Human Services administers eligibility determinations. So they are the agency that is in charge of receiving applications. They process applications. They also process terminations from coverage, but they are just making sure that people are enrolled in the correct Medicaid program. There are a handful of cases. We're going to talk about a particular program today called the EPD waiver program, which is one of the main ways that people in DC get home health services through Medicaid. Some EPD waiver cases will involve an appeal or a hearing request that involves both DHCF and DHS. For the most part, any challenge only to a person's home health hours will involve DHCF only. So some cases will involve both agencies and some will only involve DHCF, but they will probably all involve DHCF or DHCF in one of their contractors. Very, very bare bones overview of Medicaid eligibility. People have to be DC residents. They have to be low income. And in some categories, including the EPD waiver, they also have to have limited resources, meaning essentially cash in the bank. They have to meet the citizen or qualified alien eligibility criteria, which is rather limited. So there are many immigrants who live in the United States who are here legally, but who still do not qualify for Medicaid or EPD waiver coverage. And then, and I'm just going to skip to the next slide because there are different eligibility categories based on how someone receives their Medicaid. There are broadly broken into MAGI, which stands for Modified Adjusted Gross Income. That is how most people in DC are evaluated for Medicaid eligibility, but then there are a handful of categories where people are in what's called non-MAGI. MAGI is not particularly relevant for these cases. You don't really need to know that much about it. It came about during the Obamacare, the establishment of Obamacare, I guess, is a way to essentially simplify Medicaid eligibility determinations. Most people who live in Washington, DC and get Medicaid are in the MAGI eligibility group. That is the column on the left, and those are the income limits for those particular groups. Again, you don't really need to know that or memorize that. This will probably not come up in the vast majority of your cases. One important non-MAGI group, and the reason this is important is because the EPD waiver, which is an important non-MAGI group, has its own kind of separate application process. That is good for some DC residents, particularly those who are on Medicaid, because it actually has a higher income limit than some other Medicaid eligibility categories. Some people, especially those who have Medicare, in addition to trying to get some form of Medicaid, the EPD waiver may be the only way that they financially qualify for any Medicaid benefit at all. There is, however, an asset limit with the EPD waiver. The asset limit, again, is not something that will generally be litigated in these cases, but it's just helpful background. So what are the entities that actually provide Medicaid coverage? Once someone is enrolled in Medicaid, where does that Medicaid coverage come from? Who provides it? It is helpful in this situation to kind of break people down into people who have Medicare and people who do not have Medicare. For people with only Medicaid coverage, those who do not have any Medicare eligibility, they generally receive their coverage in one of three ways. The first is through fee-for-service Medicaid. You may also hear this referred to as straight Medicaid. And that's essentially where DHCF pays providers directly for that person's health care. That is a minority of the population in DC. It is, however, I believe still everyone who is enrolled in the EPD waiver. But there are also what are called managed care organizations in DC, which cover most DC Medicaid enrollees. Managed care organizations are contractors that are paid a per enrollee fee by DC to provide Medicaid coverage to people who qualify. So they get a fee, they provide that coverage, and whatever they don't pay out is kept by the managed care organization as profit. Finally, people in DC, anyone can apply for coverage under the EPD waiver. The EPD waiver, we'll talk in a little more detail in a minute, but it does have that separate application process. So just because someone is enrolled in Medicaid does not mean they are enrolled in the EPD waiver for home health services. For people who do have Medicare coverage, this is largely going to be people who are either at retirement age or who receive a Social Security disability benefit called SSDI. They can get Medicaid coverage in those same ways. They can get straight Medicaid, although it's rare because the income limit is pretty low for straight Medicaid for people who have Medicare. They can also, in some very limited situations, get MCO coverage. They can also apply for the EPD waiver. Again, that's its own application process. People apply for that separately. Or there is a fourth option called the district's dual choice special needs plan. Now, this is a new plan that started covering people in 2022, I think earlier, mid 2022. This was not around when we were handling these cases a few years ago. But it is essentially, it is a Medicare Part C Advantage plan that is specific to Washington, D.C., and that takes, it is an optional plan. People have to enroll. They don't default into this. But once people are enrolled, the special needs plan takes over for their primary Medicare as well as their Medicaid coverage. So any Medicare or Medicaid benefit that that person gets, including home health services and including home health services through the waiver, are provided through that dual choice plan. And I'll just say one more time here that you might hear me refer to this as dual choice or the dual choice DSNP plan, which stands for Dual Special Needs Plan or just DSNP. But if I say any of those terms, I'm essentially referring to the same thing. It's that Medicare Advantage plan that provides Medicare and Medicaid coverage to a certain percentage of the DC population. So in terms of actually getting home health services through DC Medicaid, what does that look like? Well, it looks different depending on what kind of Medicaid someone has. Someone who is enrolled in just regular Medicaid, that could be straight Medicaid or that could be managed care Medicaid. Anyone who is enrolled in regular Medicaid can get a certain amount of home health / PCA services if they are medically necessary. That is a benefit that is included in the overall DC Medicaid health benefits package. Now, the elderly, there is a Medicaid waiver program, a home health waiver program called the waiver for people who are elderly and physically disabled. This is generally called the EPD waiver program. This is the other main way that people who live in DC can get home health services through Medicaid. It is, however, essentially a standalone Medicaid plan or benefit. It has its own separate application process. So just because someone has regular Medicaid, that doesn't mean they get waiver services. They have to apply separately for the waiver program. It is also a higher medical necessity standard to establish eligibility for the EPD waiver. People have to establish that they need what is essentially the same level of care or assistance that they would get as if they were living in a nursing home. So it's not just that they need some help with their activities of daily living. They have to prove a very high level of care need with their activities of daily living. Now, for both state plan PCA services, so people who get services through their regular Medicaid, that's often just called state plan hours or state plan personal care aid hours. For people in getting state plan hours or who are in the EPD waiver, they both have to establish that those services are medically necessary. There is a contractor called Liberty Healthcare that contracts with the HCF to assess whether people meet that medical necessity standard, and they handle medical necessity determinations for both state plan and for the EPD waiver. They do it in a face-to-face assessment with the applicant using an assessment tool, which is called the Enter-RAI or Enter-I assessment tool. Once people are approved for some type of home health service, it is usually delivered through a DHCF contracted home health agency. These are private home health aid agencies that hire health aides and then send them into people's homes when people are approved for those services. I'm not going to spend a whole lot of time on this slide. Again, this is mainly the application process. For state plan PCA services, there's not a separate application. There is something called a prescription order form. That form is filled out by the doctor. It is sent directly to Liberty, to the contractor that does the assessment. Liberty will schedule an assessment. They will make a determination about whether someone qualifies, and if they do, for how many hours they qualify. And that if that person disagrees, if they're denied or the hours are too low, then they can appeal that decision. One thing about state plan PCA services, is that there is a limit of about 8 hours a day, 7 days per week for those hours. If someone needs more home health care than that, they generally have to get it through the EPD waiver. Now, the EPD waiver, because it's a standalone plan and benefit, it does have its own application process, and it is more involved. People contact the DC Office on Aging. They are assigned a Medicaid enrollment specialist who essentially shepherds them through the application process. It does include the prescription order form and the face-to-face assessment done by Liberty. And one key difference with the EPD waiver is that if someone is approved, they are assigned a case manager. A case manager is someone who essentially coordinates their care with their home health agency, to make sure that they are getting the benefits that they need. Another key responsibility of the case manager is that that case manager is responsible for the annual recertification process. We're going to talk about renewals for these benefits in a minute, but the case manager is the person who is supposed to shepherd the recertification process through and make sure that benefits are recertified for people who continue to qualify. And the other thing about the EPD waiver is there is essentially no limit from a medical necessity standpoint on the hours of care they can get. It is rare, but in some situations, people can get up to 24 hours per day of home health services. Now, that is usually going to be people who have extreme physical limitations or things like dementia or Alzheimer's. But we have been able to appeal some reductions from 24 hours or appeal for approval of 24 hours in a handful of cases. And we have been able to win some of those cases at the Office of Administrative Hearings. I want to talk about another program real quick called Services My Way. Services My Way is an option for people to get their home health care, but only for people who were enrolled in the EPD waiver. This is not an option for people who are just getting some, 8 hours or less of home health services through the Medicaid state plan. But the way that Services My Way works is that it allows people to essentially choose who will be their home health aide instead of getting home health aides through the home health agencies that I mentioned earlier. In order to get enrolled in Services My Way, people first have to be actively enrolled in the EPD waiver. So they have to apply for the EPD waiver and they have to be approved. Once they are approved, it is the responsibility of the case manager, if the person is interested in Services My Way, to start that process, which involves a referral to an organization called Consumer Direct. Consumer Direct reaches out to schedule a meeting. The enrollee has to have people in mind who will be their home health aides. Those people have to be approved with a background check. They have to pass a CPR certification. And then Consumer Direct works with that enrollee to set up a budget, because the enrollee essentially manages their own care and pays their own home health aides out of the budget that is approved. But even for people enrolled, now this is still an EPD waiver benefit. So even for people who were enrolled in Services My Way, they still have a case manager. And that case manager is still responsible for their annual recertification. So I'm going to talk for just a couple of minutes about how medical necessity is determined in these home health cases. The question of what level of care of medical necessity, what level of care is medically necessary for individuals is going to be at the crux of a lot of the cases that we litigate and that we will be referring out to pro bono attorneys for representation. I mentioned a little bit ago that Liberty Healthcare is the entity that conducts the assessments. They do it using the Inter-RAI assessment tool to assess an individual's level of need across a wide variety of areas. However, the main issue that we represent people on are the number of home health hours they are getting, either through the EPD waiver or through the Medicaid state plan. And the number of hours is only determined by a relatively small portion of that big, long Inter-RAI assessment. The way that it is determined is by people's individual need in certain activities of daily living. Those activities of daily living include bathing, dressing, toileting, walking / mobility, and eating. Not meal prep, but just eating. DC regulations require a score of 9 or more to qualify for EPD waiver services. And they require a score of 4 or more for PCA state plan services. When you get your pro bono manual, when the manual is released, there is a redacted notice from Liberty Healthcare at tab number 15. And these scores will make a little more sense once you take a look, excuse me, at that notice, because it shows how their individual scores that people get in these activities of daily living, they either add up to more than 4 or they add up to more than 8. And that's also what determines the number of home health hours that people are approved for, excuse me. In terms of medical necessity, that is actually not defined in DC regulations. So there is no sort of hard and fast regulatory definition of medical necessity. We've heard over the years that DHCF is going to propose a medical necessity definition, but it doesn't really ever seem to come. So in terms of appeals, especially appeals at the Office of Administrative Hearings, there are a couple of key points to keep in mind. There is no specific exclusion of medical evidence outside the inter-RAI assessment when determining medical necessity. So especially on things like an appeal, for instance, outside medical records from people's physicians, hospitals, physician statements, or even testimony. All of that is relevant evidence when someone is appealing the number of hours that they were approved for, or that they are the proposed reduction to through the inter-RAI assessment. So it's not limited to just that tool. Generally speaking, OAH rules are inclusive of any evidence that a party feels will help an ALJ, that's an administrative law judge, decide the case. The administrative law judge does make the final decision on admissibility. Generally, we argue for kind of a broad admissibility category, but then ALJs will also make a determination of the weight assigned to certain evidence. But more often than not, in these types of cases, it has generally been easier to get evidence admitted into the record. And I'm going to talk about this on the next couple of slides, but relevant case law and the Medicaid legislative history show that a treating physician's opinion is a critical aspect of any medical necessity determination. So a lot of what we're going to talk about a little bit later in terms of how to prepare for these hearings is going to focus on developing medical evidence, gathering medical records, and especially getting detailed statements from physicians that explain why someone needs the level of care that they are trying to get or that they are trying to maintain. I'm not going to go over all of these in a whole lot of detail. And in the pro bono manual at tab number 1, there is a tab that includes a lot of useful citations and links to different policies, regulations, court cases, and whatnot. So these are just some DC code citations that sort of stand for the proposition that all relevant evidence should be admitted into a hearing and put before an ALJ when that ALJ is making a medical necessity determination. In these cases as well, the legislative history of the Medicaid Act we think is helpful. It states that the physician is to be the key figure in determining utilization of health services. Just as there is no regulatory definition of medical necessity in DC, there's also not a whole lot of DC Circuit case law on what medical necessity means. However, some other federal courts and state courts have issued some opinions that we find are helpful in these cases. And they all essentially say that a treating physician, a statement or a testimony or the opinion of a treating physician is at least a very critical aspect of the medical necessity determination that deserves substantial weight when determining what level of care is medically necessary. Now, these cases don't say that treating physicians get, controlling weight, or that they get that whatever a treating physician says goes in terms of a medical necessity determination, but they do stand for the proposition that a treating physician is a very key component in the overall medical necessity determination. So that is why a big part of these cases is working with the client to get, statements, or even in some cases, we've had some luck, excuse me, getting oral testimony at hearings from treating physicians. But that is a critical component of determining what level of care is medically necessary for these clients. In terms of how home health care services are renewed, so this is a big reason why we are here today, because these renewals have not been happening, I think, as most people know, but they have not been happening since the beginning of the public health emergency. Even though the public health emergency is continuing, the continuing care provisions of Medicaid have not been continued past March 31st. So that is why we are going to start seeing notices going out to all Medicaid enrollees after March 31st. In terms of renewing state home health services, home health services, there is not a requirement for a reassessment on the state plan side at any specific interval of time. Home health services are only reassessed for people who receive them through the Medicaid state plan or, not through the EPD waiver. Medicaid home health services are only reassessed when there is a significant change in health condition. That usually means that someone is trying to get more services because they think their health condition has gotten worse, or their ability to complete their activities of daily living has gone down since their last assessment. However, people who are getting home health services through regular Medicaid do have to separately renew that underlying Medicaid coverage on an annual basis. And so if someone is getting home health services and their home health services are fine, but if there's a problem or if they don't recertify their Medicaid, those home health services will stop as soon as their Medicaid terminates. So that is something to keep in mind. For the EPD home health waiver program, the waiver eligibility is redetermined on an annual basis. There is a full reassessment every year, including an updated face-to-face inter-RAI assessment from Liberty on an annual basis. That is to make sure that people who are enrolled in the Medicaid waiver program continue to meet that high level of care that is akin to receiving services in a nursing facility. One key aspect, and I think I mentioned it earlier, of the EPD waiver renewal program, however, is that it is largely the responsibility of the case manager to initiate and complete that recertification. It usually happens that people will get a 90-day notice from the Department of Human Services. Remember, they're the other agency. They're the agency that handle enrollments, recertifications, terminations. They will get a 90-day notice of the need to recertify, but their case manager should get that as well. And their case manager should essentially start working on their recertification at that time. If the recertification is not complete, then people will get a 30-day termination notice. Now, that 30-day termination notice especially has appeal rights, as with the 90-day notice, I believe, but 30-day notice would have appeal rights, and people have a right to file an appeal to challenge that. And we have had a handful of cases where people have lost their EPD waiver coverage, or at least have gotten a notice purporting to terminate their EPD waiver coverage, not because their assessment score was too low when they were reassessed, but because there was a problem with the recertification. And I'll talk a little bit more about that later as well, but it does kind of implicate who you file the appeal or the fair hearing request against if there is any indication that a recertification issue has come up for someone in the EPD waiver. If a termination or reduction of services occurs, or someone gets a notice saying that a termination or reduction is about to occur, people have due process rights. They have the right to appeal that decision. They can appeal any adverse notice to the Office of Administrative Hearings, or internally through the administrative appeal process through the Medicaid Managed Care Organization, or the DSNP, that dual choice special needs plan. I'm going to talk a little bit more about that appeal process right now. So how do people actually challenge the reduction or termination of home health hours? In the past, generally speaking, people have filed an appeal to challenge any termination or reduction from these services with the DC Office of Administrative Hearings. The DC Office of Administrative Hearings is kind of a hearing office that hears not just public benefits cases, but it hears certain housing cases, certain cases involving the Department of Public Works. It hears cases involving unemployment insurance benefits, but it also has jurisdiction over Medicaid appeals. There's a slide coming up about internal exhaustion requirements that we are not 100% clear on yet because that is new. I'm going to talk about that in a few minutes. But staying with the OEH appeals for a second, requests are filed at OEH either in writing, it can be hand-delivered, faxed, or emailed. They can be made orally over the phone. They can be made to OAH. They can also be made to another entity called the DC Healthcare Ombudsman. And if that information is not at the end of the presentation, we'll make sure to get it out. But you can also just Google DC Healthcare Ombudsman. It's the number that comes up, and they can help people file hearing requests. And I believe they can also be filed electronically online, which is relatively new compared to years past. Usually the opposing party, well, almost always the opposing party for one of these cases is going to be the Department of Healthcare Finance. For people who have coverage through a managed care organization or the dual choice DSNP program, we suggest filing the appeal against both the Department of Healthcare Finance explicitly and whoever that contractor is. But DHCF is the ultimate arbiter of Medicaid services. They're the ultimate sort of administrator. So we always want to include them on any appeal that we file with the Office of Administrative Hearings. When an enrollee requests a hearing, and this is a really critical point, and it's something that we'll talk about a little bit later as well. But when an enrollee requests a hearing, either before the purported termination or reduction occurs, or within 15 days of the notice that they get, whichever one of those two is later, then under both federal regulations and DC code, their services cannot terminate or reduce until the hearing process is complete. That is referred to as aid pending. So if someone is receiving 16 hours a day, let's say they're in the EPD waiver, they're getting 16 hours a day of home health services, they get reassessed and DHCF or the contractor says, we're cutting you down to 10 hours a day. If that person timely files an appeal in accordance with these citations, then that reduction from 16 to 10 cannot go into effect until they have filed their appeal, they have had a hearing before a judge, and the judge has issued their decision. So aid pending is a very important part of this practice and of making sure that people hang on to those benefits while that appeal is going on. Whenever a hearing request is filed with the Office of Administrative Hearings, we want to make sure that any request for aid pending is explicit. And I think it should reference these citations. And during an initial client meeting, if you get one of these cases, if they're referred out to you, during that initial meeting, you also want to make sure that whatever adverse action has been proposed against the client, that it has not yet gone into effect, that they are still getting the level of care that they need. I mean, hopefully they will be getting a notice and they will be referred out before the notice goes into effect. But even if a reduction or termination has gone into effect, there are ways that we can get aid pending if that reduction or termination should not have happened at that time under the rules. Excuse me. So I want to explain just a tiny bit about when to include not only DHCF or DHCF and their contractors an opposing party, but when to include the Department of Human Services as an opposing party on a hearing request as well. For cases that involve essentially a termination of the underlying Medicaid coverage, that could be regular Medicaid or the EPD waiver, the opposing party will include the Department of Human Services. This is, again, as you'll remember, I said earlier, the Department of Human Services is the entity that is in charge of making sure that people are actually enrolled in the Medicaid program that they are entitled to be enrolled in. So if someone is actually losing their Medicaid coverage through the EPD waiver, it'll usually be an EPD waiver case that this will be relevant, then we want to file the hearing request against DHS as well, because if the appeal is successful, then DHS will have the responsibility of actually restoring that person's Medicaid coverage in the systems that they use. If the case involves only a reduction of home health hours, but does not include a purported termination of the underlying Medicaid coverage, then usually the opposing party will only be DHCF or DHCF and their contractor, which would be the managed care organization or the dual choice DSNP program, if those entities are involved in that person's care. Now, I just want to kind of describe briefly the most common scenario that you will see in which someone may lose, in which the hearing request will involve both DHCF/contractor and DHS. That is usually going to involve someone who is enrolled in the EPD waiver program, who has had a reassessment, and that reassessment drops them below that score of 9 that they need in order to maintain underlying eligibility for the EPD waiver program itself. So if someone, again, we'll use my example earlier of someone who is getting 16 hours per day, but let's say instead of dropping to 10 hours per day, they drop to 6 hours per day. We've seen that happen. And let's say their score was like an 11 on their last assessment, but it dropped down to a 6. And so their hours are below what someone needs in order to get EPD waiver coverage, and their score, more importantly, that score is below a 9. That person will lose their hours from 16 to 6. So they'll lose 10 hours per day of home health services, but they will also lose their EPD waiver coverage itself. Now, you'll remember earlier I talked about people who have Medicare. For a lot of people who have Medicare, they have too much income to get Medicaid any other way than through the waiver. So in those situations, people are not only losing, they are essentially losing all of their home health hours, because even though the reduction is from 16 to 6, they don't qualify for the waiver anymore. So that is the most likely fact pattern where you will file a hearing request if it's necessary against DHCF, but also against the Department of Human Services. And I'll just go back to the very top of this slide 1 second to say another situation in which DHS will be the opposing party, may be included, or in some cases could even be the standalone opposing party, is if the issue is a EPD waiver recertification issue. The EPD waiver recertification is complicated. There's a lot of steps. That's why case managers are involved, and that's why they're supposed to oversee that process. But sometimes things happen. Sometimes case managers don't have all the information they need. Sometimes they don't transfer that information in time to the Department of Human Services. Sometimes there's a problem with the Department of Human Services. So in those situations, if someone gets a notice that says you're losing your EPD waiver coverage because you did not recertify, that is another situation in which DHS will be an opposing party. So I hope that was more helpful than it was confusing. And again, something else I will say is that, and I mentioned it earlier as well, but for pro bono attorneys, anytime you take a case, you will be assigned a legal aid mentor who has some experience with these cases and who you can go to with questions. So if you're in a situation where you have a couple of notices, let's say, maybe they're confusing, maybe you don't know exactly what Medicaid is saying to the client, your legal aid, you can talk to your mentor about that, and they will help you figure out how and when to file an appeal and what that needs to look like and who the opposing party is. So I think I mentioned this 2 slides ago, and this is a new, I will say, new issue that we are seeing now in these cases. Previously, when we wanted to represent someone, or when someone wanted to challenge an appeal, they generally went straight to the Office of Administrative Hearings. There was no exhaustion requirement for people enrolled in managed care organizations, or at least it didn't seem like it was being enforced very much. We are now seeing an exhaustion issue pop up in a handful of cases. For individuals who are enrolled in managed care organizations, or people who are enrolled in the dual choice United Healthcare plan, those plans have argued in a couple of very recent cases that enrollees have to exhaust their internal appeal process before they can file a hearing request at the Office of Administrative Hearings. And I'm aware, it was not a legal aid case, but I am aware of at least one case where an ALJ dismissed a hearing request on this basis because someone did not go through the internal appeal first. But the internal appeals are going to be filed directly with the managed care organization or with the dual choice United Healthcare D-SNP plan. We have not filed a lot of these internal appeals ourselves. I don't know that I've ever filed a single one, to be honest, especially in these types of cases. The adverse notice that someone gets telling them that they're going to lose hours or lose their care will have instructions on how to file the internal appeal. You can also talk to your legal aid mentor if you have any questions about that. As far as the legitimacy of this exhaustion, we and other legal services organizations are trying to determine whether we think this is valid or not. It seems to be allowable under federal regulations, but we're not clear if it's something that has to happen under DC law and regulations. If we have a better idea of that, we will certainly pass that along, and you can also talk to your legal aid mentor about that. But one key thing I do want to talk about is this aid pending idea, because aid pending, at least under the DC statute, is specifically tied to a hearing request. I've heard that the notices also say that internal administrative appeals come with aid pending, and if so, that's great. If, however, at any point, services are interrupted, if someone gets a notice and if they have filed an appeal, either with OAH or internally, and services are interrupted, there is something that you can do. As long as that person has timely filed an appeal somewhere, internally or at OAH, if that reduction still goes into effect, you can file an emergency hearing request and an emergency motion for aid pending to be established. I will say that there is a sample of an emergency motion for aid pending at tab 12 in the binder that we've included this time. So if that comes up, you should have a sample of something to file, and you can also talk to your legal aid mentor about what steps to take. In terms of the internal appeal, again, this is something that I do think legal aid will be learning a little bit more about as we handle these cases. But in terms of how to proceed, if this exhaustion requirement does apply, and if someone has to go through this internal appeal, once that appeal is filed, we would suggest contacting the managed care organization or the dual choice plan and figuring out who the contact person is. I imagine there is someone who is in charge of the appeal from the provider side. So I think you would want to get in touch with that person and talk about how to proceed, talk about submitting evidence, and talk about just how to proceed on that appeal. The next steps, and we're going to talk about next steps in a little more detail later, but just in terms of gathering evidence, a key part is going to be a medical necessity statement from the person's treating provider, if that's something that the treating provider is willing to provide. And I will just say that in these cases, I feel like I have had more luck getting physicians to cooperate with our clients than I have in, say, our Social Security practice. It's not universal necessarily, but we have had pretty good responses from physicians, because I think a lot of physicians know that this population, they are generally elderly, they are disabled, they are elderly and disabled, they have a lot of needs. People don't want to go to a nursing facility. The idea behind home health services, right, is keeping people in their homes, letting them age in place in their homes, in their communities. And so we have had some luck getting pretty good statements, or even in a handful of cases, live testimony from physicians to support their patients' need for ongoing home health services. Additional support can be, medical records, things like that, that sort of bolster or support what the physician's statement says. I will say most often than not, it will be a statement from the physician, not live testimony in a hearing, but we have had a couple of cases where physicians were willing to do the live testimony. You can also consider statements from the client or from people who are familiar with the client's needs, friends or family members. I think one thing to keep in mind in terms of the internal appeal is that in terms of, gathering statements like this, you don't necessarily want it to be something that the client would contradict later in hearing testimony. So I think that can be just kind of a choice that you make at that time. You can talk to your legal aid mentor about it. I think those statements can be very helpful. But if their testimony is a little bit all over the place, or they're not entirely consistent with how they describe their level of need, I could see that perhaps being used to impeach them in hearing testimony. So it's just something to consider. And I think, talking to your legal aid mentor, they can probably give you or just help you think through the strategy piece on that. In terms of the internal appeal, it is unclear at this point to me whether MCOs or the DSNP will engage in any sort of negotiation during this appeal. In the past, when we filed hearing requests, DHCF has been willing to do some level of negotiation, sometimes meeting in the middle in terms of approving hours. And of course, that has to be okay with the enrollee, but sometimes enrollees, are happy to sort of settle rather than going through the sort of hassle of a full evidentiary hearing. And so that is something that I think we will learn more about. And as we have more experience, we will be sure to share that, or you can talk to your legal aid mentor about that. If the internal appeal is unsuccessful, obviously, then the next step is a fair hearing request to the Office of Administrative Hearings. Excuse me. So if you are in a position where you're filing a fair hearing request at the Office of Administrative Hearings, I will just direct you again to a couple of tabs, tab number 4 and tab number 5 in the Pro Bono Attorney Manual as sample hearing request forms for both DHCF as well as DHS, the Department of Human Services. Tab number 6 is instructions for filing documents at the Office of Administrative Hearings. Tab 7, 8, and 9, I guess all the way through 10, are just helpful things in terms of certificate of service, a sample notice of appearance, a sample acceptance of service by email, and then tab number 11 is a sample motion for continuance. Especially at OEH, there is a little bit more negotiation that can come in, or there are other processes that DHCF may want to do before going to a hearing. So sometimes a continuance is warranted to let those negotiations or processes play out. But once a fair hearing request is filed, the first step at the Office of Administrative Hearings is usually going to be a status conference. That's a status conference where all parties appear before the administrative law judge who's assigned to the case. That is not the full evidentiary hearing on the merits. That is just an opportunity to let the judge know your take on the case. The opposing party will present their sort of take on where the case is. It's an opportunity to discuss settlement with DHCF or with their contractor, who will also be there if that applies. And the judge will probably instruct the parties to communicate and see if there's any way that it can be settled or worked out without the need for an evidentiary hearing. If the Department of Human Services is an opposing party, then DHS will schedule what's called an Administrative Review Conference, or ARC. Whether you attend the ARC, I think, kind of depends on why DHCF is part of the case in the first place. If DHS is part of the case because there was a recertification issue, then I do think it might make sense to attend that, because that is something that is kind of squarely in DHS's purview. If the reason DHS is involved is because someone was reassessed and they lost their eligibility for the waiver, I don't know how helpful the ARC will be, because at its core, that is a medical necessity problem. And the eligibility for the waiver will be fixed if someone can reestablish their eligibility on appeal showing that that assessment that purported to kick them off the waiver is incorrect. If both DHS and DHCF are contractors, again, or contractors are opposing parties, there may be an arc. If it's something that you need to go to, I think that's a good thing to chat with your mentor about, or there may just be a status conference that is relevant in those cases. So I'm going to talk just for a few minutes about the fair hearing process, what the hearings look like. Historically, when we had a lot of these cases several years ago, we did have some pretty substantial success in getting these settled without a hearing. At the time, the attorneys for DHCF had a little bit of leeway in terms of hours that they could approve. I think it was usually 2 hours. Maybe they could just approve an increase in 2 hours from the assessment at issue without needing approval or without needing additional information. Additionally, in addition to the internal administrative appeal, if that applies through one of the managed care organizations or the DSNP, there was a separate reconsideration process that went through DHCF, which would allow enrollees and their attorneys to submit, a doctor's statement, medical records, and DHCF would essentially, through that reconsideration process, take another look and see if, with the additional evidence, they could rescind the decision or approve, a higher level of care than what the notice was telling that person they would be reduced to. So some of these did go to evidentiary hearings, but a fair amount of them were able to settle one way or another before we actually made it to the evidentiary hearing stage of the appeal. They probably will not all settle, though. And if a hearing is necessary, there's a few things that I want to talk to you about in terms of the hearing. The opposing party, again, whether it's DHS or DHCF, will send representatives to the hearing. If it's DHCF or one of their contractors, it will probably be an attorney. If it is DHS or if DHS is involved, they will usually send a non-attorney representative. You will exchange witness lists and proposed exhibits prior to the hearing. I believe the OAH rule is 5 days, but ALJs can have, if they want more time or if they're okay with a little less time, ALJs will have the final say in the scheduling order that sets out the timeline for submission of proposed exhibits and exchange of witness lists. You'll want to work with the client at that point and any witnesses other than the client that you may want to call to prepare their testimony. Again, I think that, and I'll talk about this in a couple of slides, but this can be an intimidating process for these clients. I think OAH is not a super formal venue. The formal rules of evidence don't apply, although they're sort of a guide and the judges do enforce some of that. But they are comparatively, I think, informal hearings as compared to like DC Superior Court or something like that. But that said, they can still be intimidating. The client will be cross-examined by the DHCF or other lawyer or DHS in some cases. So you would want to work with the client to prepare their testimony, explaining, why they need the care that they do, what their activities of day, what help they need with their activities of daily living, kind of what their day in, day out experience is like, and why these are critically important health services for them to remain in their home. You would also want to prepare to challenge evidence that you don't think should be in the record that the other side is trying to admit, and cross-examining their witnesses. Most of these, again, will be these medical necessity battles that we will have. And usually the witness for DHCF or their contractor will be some, kind of like a doctor or a medical director, maybe a nurse practitioner. It will be some sort of medical witness who will have reviewed the record and who will testify that they think, based on their examination of the record, that the reduction is medically appropriate for that person. And so, again, especially if you are preparing for a full evidentiary hearing on the merits, your legal aid mentor will be there to give some guidance, to talk about strategy, and to just offer some assistance as you're preparing for that hearing. After evidence is submitted, judges vary on which side goes first, but both sides will have an opportunity to present their case, to cross-examine the other side's case. Once that is done, usually the legal argument is going to be submitted in a closing statement. In a handful of cases, a very, very small number, ALJs have asked for legal briefs, but that is not common. Typically, the closing argument that the attorney will make, referencing the cases that we did earlier in the presentation, will be made as part of a rather, kind of all-encompassing closing statement that reviews the evidence, that goes over the legal standard and makes an argument for why the termination or reduction that is being proposed is medically inappropriate for that client. The other side will also have, of course, an opportunity to sum up their case, make their legal argument, and then the case will go to the ALJ. ALJ decisions at OAH, they kind of vary widely in my experience. They can take as little as a few weeks in Medicaid cases, but more commonly, they might take a month or even a couple of months. So at this point, these are the last couple of substantive slides, and then I am going to, we have some information at the end, just some contact information that is helpful, and then we'll open it up to questions if anyone has anything. But I want to talk now about, if you are referred a case, if a case is referred over to you, what does that sort of initial meeting and preparation for representation look like? There are a few things to keep in mind, I think, for this client population. A lot of the clients, almost all of the clients, are either going to be elderly or have some kind of physical or mental disability. This may well be the first time that they have met a lawyer, or they may have had bad experiences with lawyers in the past. A lot of them are not going to understand what's happened, why their benefits are being threatened with reduction or termination. I think that is especially true now for what we are about to see, because so many people have not had to worry about recertification over the last 3 years with the public health emergency. So I think folks might be confused about what's going on. Every single person who is going to be affected by the restart will get notices, or at least should get notices, before any adverse action is taken. But again, maybe people miss those notices, or maybe they don't see them right away. It may just have been a while since they've had to go through this. So, I think that, there just may be a little bit of confusion on the part of clients, and they may have a lot of questions. So I think, working with them and kind of bearing with them to make sure that they feel comfortable with the assistance we're providing and with representation is a really important part of doing these cases. You'll want to have, obviously, an initial meeting. Whether you do that in person or over the phone, I think depends on your comfort level, the client's comfort level. We're meeting with clients in person, but we're also doing a fair amount over the phone and over computer these days still. But, whether that initial meeting is in person or not, you'll want to get a retainer agreement or engagement letter signed. You'll want to have the client sign some health release forms so that you can reach out to their physician, any hospitals or other providers that may have relevant medical records. You'll want the client to give you copies of any relevant documents. Those are going to be things like the notice that they have received that is telling them that their benefits will be terminated or reduced. They may have medical records. They may have other relevant documents that will just help you understand the case. So sort of any document that the client thinks you should take a look at, you can get those, make a copy, and have those to review. A big part of the initial meeting is going to be having a detailed conversation with your client about what level of assistance they need and what level of assistance they are getting from their health aides on those activities of daily living. As I said, the activities of daily living, the scores that they get on the assessment, that is really the crux of how many hours they are approved for through either the Medicaid state plan home health services or the EPD waiver home health program. So really making sure that you have an understanding of what level of help they need with each one of those individual activities of daily living is going to be really helpful and give you a really good idea of what the underlying merits of the case in the appeal are. I will say, I think one thing that is helpful to remember is as people are trying to get more hours, as people are trying to get more than sort of 12, 13, 14, up to 16 hours per day, in some cases more than that, 18 or 24 hours per day, I think it becomes really important to have some kind of argument or some kind of understanding for why that person essentially cannot be left alone. When I think about these cases, when I've represented clients in these cases, I've sort of distinguished in my head the activities of daily living that sort of happen once and they're done, things like bathing, things like dressing, and then the activities that can happen sort of throughout the day, which I think is mainly going to be things like toileting, getting on and off the toilet, hygiene on the toilet, and transfer and mobility. People don't want to sit in their bed or sit in a chair all day, but if their health condition is such that they cannot safely move from sitting to standing or getting out of bed to a standing position or get from one side of their home to the other, if they have real trouble doing those kinds of activities, and if that can be documented with medical records and a physician statement, I think that is how you form a much stronger argument and a much stronger appeal for establishing medical necessity for some of those higher number of hours that a lot of our clients do see. Because again, at the end of the day, this is about trying to keep clients in their home and providing whatever level of care they need in order to successfully do that. So in addition to that conversation, you also just want to make sure that you're getting relevant information on who their providers are. That's going to be the primary care physician. Perhaps they have specialist physicians who are also, in addition to a primary care physician, who are also in a position to describe what help that person needs on a daily basis. In some situations, specialists may even be a more helpful source than a primary care physician. People with physical disabilities, things like that, an orthopedist or a physical medicine doctor, specialist that they see might be kind of the key testimony that you want to get, either written or oral testimony. Other providers might have relevant medical records as well, hospitals, clinics, urgent care facilities, things like that. And then finally, talking with the clients about anyone else who might be able to kind of accurately and credibly describe what type of help they need on their activities of daily living. Family members, friends, neighbors, people who live in apartment complexes, neighbors can often be very helpful and have a really good sense of what help people need when they need it. Often neighbors are the people that step in and provide services if people are not getting the hours that they need right now. So asking those kinds of questions, getting those contacts, following up on those contacts with the client's permission is also a really important aspect of preparing these cases for appeal. After that initial client meeting, what are the next steps? Well, you want to either file the appeal, including a notice of appearance with the Office of Administrative Hearings, or if it's required, file the internal appeal with the managed care organization or the dual choice plan, the United Healthcare plan. You want to make sure that people are getting aid pending. If services are not being provided, that's, I think, the immediate task is to make sure that you understand why they are not and whether they can be reestablished. if someone was getting 16 hours and they've been reduced to 11, if for whatever reason that reduction has gone into effect, despite filing an appeal or despite still having time to file an appeal with aid pending, that is essentially an emergency for that client. And you can consider an emergency motion or hearing request to OAH. You can talk to your legal aid mentor about things to do. It may be an issue with the case management agency or the home health agency. Maybe they, I will say there was a sort of fact pattern that we saw when these cases first started a few years ago, where the case management agency or the home health agency, through the computer systems that they have access to, would actually see a proposed reduction before a notice was sent to the client, and they would just implement it right away. Because I think it's because they thought they weren't going to get paid going forward, but of course people get aid pending, and those reductions can't go into effect until after the notice gives them information about that. So, but we did see a fair number of situations in which people had not even gotten a notice or had gotten a notice, but still had time to appeal and had that reduction go into effect. I don't know whether we're going to see that as much this time around, but it is possible. And if it's not that, it could be something else that lets the reduction go into effect. So it is possible that you will talk to someone, they will say, I'm not getting the 16 or whatever it is I was getting before. The reduction has happened. So I would talk to your mentor at that point and consider filing something right away to reestablish that aid pending. In cases that involve that failure to recertify, if someone has gotten a notice that only says, your EPD waiver is terminating because of a failure to recertify, you'll want to talk to the case manager right away. That case manager is responsible for the recertification. You may also need to reach out to the Department of Human Services. We can share contact information, relevant contact information for the Department of Human Services. Often those recertification cases they really are an issue of just getting the right piece of information to the right person. Assuming someone who is in the EPD waiver has been reassessed for essentially their same level of care, if they are still terminated due to a recertification issue, then it may just be that there was some kind of glitch, there was some problem with the computer, there may be like a single document that the case manager didn't get, or that maybe the client didn't have when the case manager needed it. But a lot of times those can be fixed just by making sure that DHS and the case management agency have the right piece of information and making sure that that is processed correctly. In these medical necessity cases, when there is a dispute over medical necessity against DHCF or the managed care organization / dual choice program, in terms of preparing for that, next steps after the client meeting, you will want to request medical records from the primary care physician and any other relevant providers that you have discussed with the client. You will want to reach out to the primary care physician or any other physician that the client thinks might be able and willing to submit a statement in support of their appeal. Again, there is the sample, there's a redacted physician's letter at tab 17, but I just want to talk for a couple of minutes about what these physician statements should look like. They should be as detailed, essentially, as the physician is willing to make them. It is the more detail, the more that you can sort of paint an individual picture of your client's challenges and their need for these home health services to the ALJ, I think the stronger that case is going to be. So really going through on an activity of daily living by activity of daily living method, making sure that every single piece of assistance that the health aide needs to provide to that client is documented over that physician's signature is going to be really important. One thing that we have had some success doing, because again, you're going to have access to the client's testimony, to their story, probably to some medical records as well. One strategy is to actually take a shot at drafting a first try at one of these medical statements. You can send it, you can offer to do that for the physician. I think physicians appreciate that. It makes it easier and quicker for them. It is important, of course, that they see that and that we send that to the physician. They get to review it. They can make whatever edits or changes that they feel are appropriate. We usually ask that they put it on their letterhead and that they then sign it and send it back to us. But, being involved with that kind of drafting of a first try at the statement can really help make sure that all of the detail that you want to get in front of the ALJ is included. Because I do think sometimes, not through any malice or anything, but just sometimes because they're busy, physicians want to say something like, it is medically necessary that this person receive their continued 14 hours of care. And, it may, if left to their own devices, they may write kind of a very short statement that doesn't really get into the level of detail that is most helpful in these appeals. So I think trying to be involved in that process, trying to make sure the doctor understands what we need in that statement, and even offering to take a try at a first draft for them to review can be very helpful and can let you really maintain control of the narrative of the case for the ALJ. And then you will want to contact the opposing counsel, the DHCF counsel or the managed care DSNP counsel, whoever it may be, and discuss submitting records and a physician statement ahead of the hearing, if that's something that they are interested in doing, with a goal of trying to possibly settle the case before an evidentiary hearing happens. Again, I've had a handful of these cases where, the opposing counsel said, what we really need is a physician statement. If you can get us a physician statement, then we will really take a close look at that and see if we can reverse the decision. Now, it doesn't always happen, but there are, I've had a couple of cases involving 24 hours of care where I'm not 100% sure why the person was assessed for less to begin with, but the client had dementia. And the opposing counsel was pretty clear, if you get something in writing, detailing the dementia, then we will work very hard to resolve this. And we were able to resolve that without hearing. So that is essentially the end of the substantive portion of the training. The next handful of slides I do want to go over just very briefly. This is the contact information for the Office of Administrative Hearings. That is their email address. You can use that to file an appeal request or a hearing request by email. There's also the link for online filing as well. This is the contact information for the managed care organizations and the United Healthcare dual choice DSNP plan. This is a link to their provider manuals. I believe it's their provider manuals, or that may just be the websites. Actually, I think the provider manuals are in tab 1 of the pro bono training manual. But these are just the websites and their phone numbers for reaching out, if you're in a situation that does involve an internal administrative appeal, you want to either file that appeal or it's been filed and you want to try to reach out and talk to whoever's in charge of that appeal, see if there's anything they need, see how to submit evidence, see if they will negotiate. This is the contact information for reaching out to those organizations. This is the contact information for just a couple of agencies that may come up. The DC Office on Aging, they are in charge of the EPD waiver application process, like I described. Liberty Healthcare, that is their email and phone number. If you are trying to get a copy of someone's assessment, the case manager, if it's an EPD waiver case, should be able to give that to you, but often I have had to reach out directly to Liberty. And I've had to kind of stay on them because their responsiveness can be a little bit hit or miss in terms of getting those back to you. If the case is at OAH, though, you should also be able to get that from the opposing counsel. If any cases involve Services My Way, this is just the contact information for Consumer Direct. I don't know that you will have to reach out to Consumer Direct very much in cases involving a medical necessity. They really are just a contractor for setting up the Services My Way program. That kind of assumes that the person's underlying waiver eligibility is intact. But there could be situations in which you need to reach out to them, and you can talk to your mentor if you think you do, but that is their contact. Finally, Sylvia spoke earlier, introduced herself. This is her contact information, and at least for the next couple of months, I am personally going to be out of the office, but Nina Wu, who is a supervising attorney in the public benefits unit, will be available for substantive questions, as well as perhaps other legal aid mentors. But if you're assigned a case and you have a question, you can reach out to Nina, and as well as your assigned legal aid mentor right there. So at this point, I just want to thank everyone for listening. I know that was a lot of information. I ended a little bit earlier than I planned, so I think we have more than enough time for any questions that people may have. And I'll just say, I don't see anything in the Q&A right now, but if anyone, assuming they are able to, if anyone can unmute, they can ask their question, or if you're not able to unmute, you can just put it in the Q&A.
Andrew, I think in this webinar format, they are unable to unmute. But I think I will toss one question to you that hopefully will be a softball. Why don't you talk a little bit about the timing of these cases for folks who may be new to this or are coming back and need a refresher?
Do you mean the timing of renewals, or just kind of the timing of how a case proceeds?
The latter.
Okay, so I'm going to talk first about the hearing process. From the time that someone gets an adverse determination telling them that either a reduction will go into effect or that a termination of their home health services or EPD waiver coverage will go into effect. I think the first timeline to have in mind is that aid pending deadline. What is the date based on the date of the notice that someone has to file an appeal in order to make sure that they keep those services while the appeal is pending. Again, that is, either before the determination goes into effect or 15 days after the date on the notice, whichever is later. Once an appeal is filed, it's usually a few weeks, I would say, until a status conference is scheduled. It may be as soon as a couple of weeks. It may be a couple of weeks after that. And after that initial status conference, I think it kind of depends on how the case proceeds. You'll want to talk to the opposing counsel. You'll want to see if they think there may be a way to settle this. That may involve, you will want to make sure that you have time to gather a medical statement, to gather medical records. If you're going to use a statement from the client or any of their family members or friends, you want to make sure that you have enough time to do that. I think, that can take a few weeks sometimes, especially, to send out a request to a provider and to have them process it, send you back the medical records, also to reach out, make contact with the treating physician and getting, hopefully what will be a strong statement from that treating physician. I think you want to make sure that you have enough time to do that. Assuming that there is going to be some kind of negotiation, I think it depends on the form that takes. I may be misremembering this, but I seem to remember something like if the Department of Human Services wanted to do the internal reconsideration that I talked about, that might take something like a month or maybe 30 or 45 days. I can't quite remember, but it was on the order of several weeks. So there may be some amount of time for the negotiation or reconsideration process to play out. That will include the amount of time that you as the representative need to gather whatever evidence you want for that. If that is successful, then, once you get sort of an approval notice or a notice rescinding the reduction, that is usually the end of the case and you can withdraw the hearing. If that is not successful, usually a judge will set kind of ongoing status conferences, especially if at that first status conference, both sides report to the judge, we're going to try to settle this. This is what form that will take. The judge will probably set another status conference for maybe 30 days out. If you tell them it may take a little bit longer, maybe 45 days. I mean, I think the judge will usually want to set another status conference to keep things moving. But in terms of the exact amount of time that you will have, I think that'll be something that you and the opposing side can usually propose together to the ALJ, and the ALJ will usually accept that if it's not, months and months down the road, which it shouldn't be. And then, if it does go to an evidentiary hearing, if you're not able to resolve things through negotiation, through reconsideration, then usually what would happen is that whatever the next status conference is, the parties will report that they have been unable to resolve the case, and asking for a date for an evidentiary hearing, which will usually probably be a couple of weeks out from that status conference. It depends on the ALJ schedule. It depends on opposing parties' schedule. It'll depend obviously on your schedule. So these are typically representations that I think last on the order of a couple to a few months.
Thanks, Andrew. I know that folks are always interested in knowing timeline of these things. We had a question come in about training materials, and yes, we'll be circulating those along with the recorded, with this recording for folks so that they can go through the PowerPoint slides, they can go through the manual. We know some of you may be new to this, so we want to make sure you are feeling well prepared for it. I don't see any other questions coming in, but I can throw another one to you, Andrew, just so that we've got some more information being shared. Why don't you talk to us about how often it is? I'm sorry for the child screaming above. How often is it going to a full evidentiary hearing as opposed to just being settled informally? Can you talk to a little bit about that?
Sure. This is one of those areas where I think we will have to see how that plays out a little bit under these circumstances. The best reference I have for that is when we had a whole bunch of these cases back in late 2018, 2019, before the public health emergency went into effect. Most of these cases settled without an evidentiary hearing. I think internally at Legal Aid, we had dozens of these cases, I would say. I mean, I know we've referred a few dozen probably, or at least a couple of dozen out to pro bono firms. I think we definitely had in the single digits of full evidentiary hearings, I think kind of mid single digits. So between sort of negotiations around, again, sometimes a client may be getting one amount of hours. Maybe they're getting 15 hours and maybe they're reduced to 10. And maybe 10 seems like too few, but maybe they don't feel like they need 15. Maybe 12 is okay, So I think we need to see a little bit sort of how DHCF approaches negotiations, what sort of flexibility they have. But I will just say that historically, once we have, especially if we've been able to get, a good physician statement, maybe backed up with some medical records that supplement the statement, and perhaps, a statement from the client or someone who's familiar with the client's situation. We have generally been able to get pretty good results for our clients once we filed an appeal by submitting those materials ahead of the evidentiary hearing. So I would say historically, not a lot of them have gone to evidentiary hearings, but again, this is kind of a new situation, and I think we'll just have to sort of see how that plays out. But I will just say that no matter how the cases proceed, people can always reach out to Nina or to Nina and me when I'm back, or their legal aid mentor, to talk about how to prepare for a hearing, because we do have experience litigating these at OEH in the full evidentiary hearing context, and we can certainly be a resource for people who need that.
I've not yet seen another question come up So I will keep throwing the questions that I typically get from pro bono attorneys to you, so you can answer in this recording. A lot has changed with the pandemic. In Superior Court, in administrative hearings that we see with our public benefits cases. Can you talk to us about what you anticipate in terms of when these hearings are held and how to conduct these cases, whether a lot will be done remotely? Yeah, I know in the Social Security sphere, we've seen things move over to telephonic hearings. Can you talk to us a little bit about what our pro bono attorneys can expect when they take on a case like this?
Sure. Most of these cases, as I understand it, will still be done over the phone. So I don't think that OEH, especially on the public benefits or Medicaid side, has really moved back in any sort of significant way to in person. In particular, as I said earlier, this client population in particular, it's a lot of people who are elderly, a lot of people with disabilities, a lot of people with a very substantial health problems. Some of the clients may not be comfortable going back to OAH at this point in person, especially for kind of a, if it's an extended hearing, if it does go to an evidentiary hearing, which can last a few hours, being in a indoor room, a relatively small indoor room in that situation. So my understanding is that these are largely being done by telephone right now. I don't think OAH has set up any kind of video conferencing, so it's usually done by phone. And you'll just want to make sure that the client, has the dial-in number, that they have the code. A good tip is to also maybe have another way sort of offline to communicate with the client. Maybe that's texting or something like that, where you can sort of shoot a message to the client if you need to, that the ALJ won't hear, because in a hearing, of course, you could sort of step outside or have the room if the client can't leave and have a confidential conversation. But yeah, and then, all of the exchange of witness list and exhibits and whatnot is usually done over email with the opposing counsel. I think there may be a page limit on how much can be filed over email with OAH, but we can also, have someone go to OAH, or I would assume firms can have someone go to OAH to drop something off that needs to be filed in person as well.
I'll just piggyback on that I think that this is a great time to remember that when you are, when we refer a case to you, to reach out to your mentor for tips, whether it's preparing for that hearing that may be handled remotely, working with your client to make sure that that goes smoothly, everyone is on mute when they need to be on mute, especially with folks who may not be as tech savvy. So just a thought to put out there.
I still don't see any other questions in the Q&A, and I don't want to keep anyone longer than I need to, especially on a Friday afternoon, but I will just stay for a couple of additional minutes in case any other questions pop up. But I just want to take this opportunity one more time to thank everyone for participating, folks at the firm who are participating, and for being willing to take these cases. I will say one thing too is, we're still sort of waiting to see what this looks like, whether it's going to be sort of a massive deluge or whether it's going to be a little bit more restrained in terms of the initial number of cases. The rules allowing Medicaid renewals to restart say that, I believe only 1/9 of any state's Medicaid population can receive a notice in any given month, up to 1/9, and it's supposed to be a 14-month unwinding process. The information that we have from DHCF is that the initial notices will likely go out to people that they believe do not qualify either for the Medicaid or the waiver anymore, and are only still enrolled because of the continuing coverage portions. So we sort of have reason to think that we may the initial month or two of notices may involve people who are getting a termination notice, but we will just sort of have to see how that plays out. You know, there might be a lot of cases that are front loaded, or it may be a little bit more of a process or a trickle, so to speak, in terms of how these cases play out and how many we start seeing over the coming months.
Thanks, Andrew. Well, I hope you all found today's webinar informative. As Andrew pointed out, these cases are not going to pour in immediately. Renewal notice is going out in April, and then there'll be a lag from that point from when clients come to us. The number of Medicaid enrollees who may be disenrolled during that unwinding period is not clear, but we are certain that folks will lose coverage, and we are certain that those with disabilities and limited English proficiency are at greater risk. We want to make sure that our client community retains their Medicaid coverage. So all that is to say, we will be in touch this spring and summer to provide updates on what we're seeing and share available cases for pro bono referral. When it comes to the referral process here at Legal Aid, I share cases that we've screened internally with partnering firms. Once a pro bono attorney indicates an interest in a case, I can then share conflicts information. And when you receive approval from your firm, I can then connect you with your client and share all relevant documentation that we have and introduce you to your legal aid mentor. Thank you to Andrew for pointing out several times throughout this presentation the different ways that your pro bono mentor can help you throughout this process. You should consider them an additional resource in addition to the written and recorded training materials that we share with you. Though I want to be clear and highlight that your legal aid mentor will not be co-counseling the case with you. They will not attend hearings with you. They will not attend client meetings. But we are here to support you when you have questions about who you're appearing before, hiccups that may come up, even just as we mentioned before, handling these cases remotely. We are here to support you. So we thank you for joining us to get a head start on this important topic as we get ready for the return of Medicaid home health cases. If you have additional questions or didn't get to put them in the Q&A box, please feel free to reach out to us. Thanks so much for joining us.